Joining me now is Kate Kempton, Senior Counsel at Woodward Co. She represents a coalition of First Nations taking legal action against Ottawa and Ontario's infrastructure bills. Good morning. Thanks so much for being with us.
Thanks for having me.
So what legal basis does the federal government have for asserting that it can bypass laws through both of these bills, Bill C-5 and Ontario's Bill 5?
We say that they don't have any legal basis, that what they're doing is throwing away the Constitution to get, ostensibly, to get major projects built. And again, ostensibly because of threats south of the border, but we're basically becoming what we say we're threatened by if we do this. There is no constitutional right to wave a magic wand if you're provincial or federal cabinet and say that all of these laws are not going to apply if we on a whim decide they're not going to, because those are the very laws that require assessments, environmental and archaeological assessments, a number of environmental and human rights protections, permits to be applied for and conditions to be put on. And so, you know, that if all of those things go out the window, then there'd be nothing to engage First Nations about. The engagement with First Nations has to be meaningful. It has to ensure that their concerns are understood, which means we need to do assessments and gather facts, and then addressed. You know, how do we avoid, mitigate, compensate for, and otherwise address all of these impacts that are likely to occur if we don't even know what they are? We're not even taking the steps to find out. And so, I mean, what we're saying in this is we're not against economic development, but we are against it at all costs and without regard for constitutional values, constitutional rights, and environmental protection.
So did you hear the Prime Minister's opening comments today? He spoke about partnership, and he said that it would be these projects would be for the gain of all Canadians, that everybody would reap the benefits.
There's a couple of things to say about that. You know, for First Nations, it's being at the decision-making table. That is their constitutional right. That's the requirement of the Crown to advance reconciliation. It's a constitutional obligation, and that means inclusion in decision-making, not propagandize, well, don't worry, we'll talk to you when it doesn't really matter. If Carney and the federal government mean what they say, then put your money where your mouth is, put your law where your mouth is, and change the law, because Section 6 and 22 of the Federal Building Canada Act say the opposite and give the authority the opposite of what Carney's saying today. Why should we believe them when their law grants them the power to do the opposite?
So is there anything today, Kate, that could come out of the summit that would prompt you to drop this lawsuit?
Yes. I mean, obviously, I have to take instructions from our clients, the First Nations, but if they repealed Section 6, which is we deem all projects that we're going to declare as national interest projects, like essentially pre-approved. There's no option. So it's biased and slanted decision-making from the get-go. And Section 22, which is the absolute power provision to Cabinet to exempt projects from the application of all the other laws. If those two provisions came out, there's a very good chance that we would drop our legal case against Canada, because those are the two extremely offensive and offending provisions. They're unconstitutional.
Kate Kempton is the Senior Counsel at Woodward Co. Really appreciate your time with us, and of course we'll be following to see how all of this plays out. Thanks again.
Thank you, Marcia.